This is your final episode for our criminal procedure review course. We started this course with a discussion on the difference between criminal law, the what, and our expectations from the law, and our oath to serve, the very rights and responsibilities we're supposed to enforce. And then criminal procedure, the how, in the sense of the law's expectations of us when dealing with people as we enforce the criminal law. And up to now, we've talked about all of the various basic expectations of the procedural side of the law and how it sets the parameters for the rights of people as we interact with them from initial contact all the way through arrest. And to be clear, there's a lot more. This is a basic review. There's a lot more. Things we aren't going to cover here, things we've not touched on, things as an example like interviews, interrogations, confessions, procedural expectations for lawyers, the courts, the justice system. Things that you encounter, you may have done as a police officer, but things that we could spend an entire course on. The interview, interrogation, confession area as an example. It's a whole set of classes, and if you find yourself in that role, get enrolled in a class or reach out. I have a lot to share on those topics, but it's beyond what we decided to go with in this course. Now that said, while there's a lot more that we could dive into that is traditionally procedural law, use of force wasn't a topic we saw as covered traditionally under criminal procedure. It wasn't in textbooks. It wasn't focused on specifically as a procedural thing in training courses. And it still isn't, in my opinion, widely covered as a procedural topic as much as it could and should be. I think it should be. And if you didn't know it before this course, you should know why now. Nearly every aspect of everything we have discussed to this point offers an opportunity for circumstances to dictate force could, emphasis on the could, be used. Now, we've talked about cases that were as old or older than myself. And we've already established that I'm old. Case law in this area isn't that old. Statutory law in this area, specifically focused on use of force, is not that old. Guidance for police officers in that respect, in the same respect as the other topics we've talked about, is not that old. Still, as you know, the attention brought to the use of force by police officers in recent years has created a lot of additional scrutiny. And in Illinois, it's brought defined statutory expectations for what force is and when and how it's appropriate under the law. As a result, I added this topic as an important part of our own procedural law courses some time ago. I did that really for two reasons. First, I just don't want to wake up and read about or get a phone call about any of my former students involved in the misuse of force, alleged or actual, and especially not deadly force. I don't want it for them, my community, the person who's harmed, or worse, by a police officer failing to follow the law. Just don't want it. Second, it's really not that complicated. It comes back to a basic knowledge of many of the practices, principles, and expectations of the law that we've already reviewed. As an older practitioner, someone who started down your path, someone who studied and followed the law served it in different ways for many, many years. I don't see any of the expectations of the statute, the public, your community, your department procedures. I don't see it as new. I don't see it as being complicated. And to give yourself a break, you should not either. If you take all of what the law expects of you on every topic we've covered to date, from the first encounter with a person, all the way through an arrest and everything related, and you consider and follow what the law expects of you at each of those junctures, the expectations for the use of force in those interactions, they're spelled out for you in the same context as those other expectations. The reasonableness of the action under the circumstances. It's how your actions are scrutinized as either sound or questionable in everything we've discussed to this point. Whether you should have used force and to what degree force was warranted doesn't fall under a different standard. What the law expects of you in this area is not more complicated than what it expects of you in all those other things we've talked about. The difference is that when use of force becomes a question, the circumstances have shifted to a concern over the safety of someone else, a bystander, a victim, you yourself, or the suspect. Like the situations we've discussed in the other topics we've covered in this course, it is generally when an officer gets sped up, they fail to take that deep breath. They fail to fully process the situation. It's then that they fall outside the options and expectations of the law, and it's then that we see issues arise. And in this area, those issues can be fatal to a living human being and a career. Now, none of us are infallible. And all of us step in a pile of dog doo from time to time. And sometimes the circumstances that we find ourselves in make us more prone to stepping into that pile of dog doo. Sometimes we allow ourselves to be sped up and we aren't being focused and intentional enough to avoid stepping in the pile. You're going too fast, you're not paying attention to what's ahead of you, you don't see it, and you step in it. The law calls these situations negligence, and you deal with negligence daily in vehicle accident calls and other non-intentional, non-criminal interactions that you're sent out to help sort out every day. Beyond those negligent, unintentional actions, sometimes people do things intentionally, something they should not do. And we know that these intentional acts often end up with the loss of victims, sometimes tragic circumstances. You're familiar with these scenarios as well because this ends up being the most important of the calls you respond to each day. And that's about as basic as we can make the reality of human behavior as you deal with it, and we expect you to deal with it under the law. But just like the people that we interact with, we also step in it from time to time. And whether it was that we weren't following procedure and got too sped up, and really didn't have any intent, or we had just a careless moment, or if we did something intentional, regardless of the circumstance, how we end up there, we step in the dog do. The silver lining is that most people, you, me, people in your family, your friends, your circle, your community, majority of people. I used to hear cases on properties and criminal nuisance properties and everything related to properties. And sometimes people would get on a high horse and lump a bunch of people within a particular area, block, neighborhood together. And I know, and I think you probably know, that the majority of people that you end up dealing with each day, they just want to live a peaceful life. Now, they might not always live like you would choose to live or I would choose to live, and they may have circumstances that make their life more chaotic than our lives, but they're not out there looking to do harm. That's most people. And going from that, I think that most people generally try to avoid stepping in it. I mean, as difficult as your job is, holy heck. I mean, what if you had to deal with more people who just don't care or intentionally step in it? But the fact of the matter is that somewhere in life we learn the consequences, directly and indirectly. We learn those things, and other people did too, and we genuinely try to avoid stepping in that big pile of dog doo. Because we know that regardless of how we got there, it's a mess, it stinks, it has to be cleaned up. We don't notice or aren't careful enough to notice we stepped in it, or we're inclined to, as some people do, pretend that they didn't step in it, or worse, the people who just disclaim all responsibility for stepping in it. That stench and mess will follow us around for a good long time. The most basic principle of this entire course has been to suggest that you do what you can do to avoid stepping in the pile of dog doo. But on this topic especially, you need to be dialed in, head on a swivel, deep breaths. Don't get sped up. Follow the law. And that's true on everything, but again, because of the potential cost here, you really need to be dialed in when you get to this stage. Now, I won't dive into any specific case of gross negligence or intentional acts that caused harm or death unnecessarily. You know the cases. You know the names. You've seen the video. You've heard the excuses, the criticism. You've seen what happened at trials, plea agreements, convictions, how careers ended, how people that are supposed to be enforcing the law went to jail themselves. You've broken down those circumstances alone, with your friends, with your coworkers, in department briefings or other courses. Any way you slice it, these cases fall into those categories of stepping in the pile of dog doo I described: negligence, gross negligence, or intentional acts. Now, I know you won't do that. I know you're going to, and you do, try to avoid stepping in it. But even if we aren't the person who stepped in it, we're not even remotely close to the same geographic location, states away from whoever stepped in it. Those situations make our jobs tougher. It doesn't help your agency recruit or keep qualified coworkers for you, so you have to work, extra, lots of overtime, lose your valuable time off, be stressed. It doesn't help people like me recruit and educate enough qualified candidates for all the open positions we are all experiencing, we all can't fill. It puts us all on the defensive in too many conversations, when the reality is that you wouldn't do those things. You wouldn't have done those things. You wouldn't have allowed those things to happen to the best of your ability. And you won't, because you will know and you will follow the law. For this topic and everything else we discussed in this course, you will know the basic expectations of the law. You will take a deep breath. You will process the circumstances and how the law applies to those circumstances. And then you're going to trust yourself and act accordingly. Let's talk about use of force and the case and statutory law expectations. As I noted, until recently, we didn't have a lot of law guidance, cases, or statutes on use of force. The most common definition of what use of force is was developed by the International Association of the Chiefs of Police, and they defined police use of force as the amount of effort required by police to compel compliance by an unwilling subject. The amount of effort required by police to compel compliance by an unwilling subject. And although use of force is often viewed, we think of it in the physical sense, physical force, as we fleshed out in our earlier episodes, the use of force may refer to verbal commands issued by police to direct an individual through certain actions. Don't move. Hands up. Those things can be viewed as use of force, those verbal commands. Illinois statute states that an officer is justified in the use of force when he reasonably believes, based on the totality of circumstances. So reasonably believes on the totality of the circumstances. Force is necessary to effect the arrest and for any force he reasonably believes based on the totality of circumstances to be necessary to defend himself or another from bodily harm while making the arrest. That's 720 ILCS 5/7-5. Unlike the other topics that we've discussed in this course, there's not a lot of specific use of force guidance from the Supreme Court. Now, why is that, you might ask? Well, it's because to get to the question or issue about whether use of force is reasonable, there has to have been some interaction between the individual and the police officer prior to the force. And when things go sideways enough to create a use of force issue, most often or more often than not, there seems to be some circumstance or occurrence that wasn't quite right in one of the other areas we've discussed in the prior sections of the course. I mean, keep that in mind. As I said, from initial interaction with somebody through arrest and everything in between, if you think about it, if you break down those circumstances of all those cases that you've reviewed that we've all hoped would never happen and wished that hadn't happened, I mean, think about it. Somewhere along the line, things went sideways. And the actual first interaction, and whether the person is detained or in custody, and the arrest, somewhere along the lines, things went sideways. That said, there's two cases that I want to review. Two cases you should have some basic familiarity with regarding the use of force and the use of deadly force. First is Graham versus Connor. 490 U.S. 386, a 1989 case. And this case involves a claim of excessive force by law enforcement during an arrest, stop, or seizure of an individual. And it essentially says that that the arrest, stop, or seizure is subject to the objective reasonableness standard of the Fourth Amendment, rather than the substantive due process standard under the 14th Amendment. In other words, the facts and circumstances related to the use of force should drive the analysis, and that's rather than any allegations of improper intent or motivation by the officer who used the force. Now, in that case, Graham was a diabetic, and he began to experience an insulin reaction. He asked a friend to drive him to a convenience store to buy some orange juice. He hurried into the store, but it was crowded, and he became concerned that he wouldn't get the orange juice in time, so he asked his friend to drive him to another individual's house. A police officer was standing there and noticed that Graham entered and left the store quickly, and without doing any further inquiry or investigation, he followed the vehicle Graham was in and stopped the vehicle. Other officers arrived, and the short story is that Graham sustained injuries as he was handcuffed at the scene. They found him to be erratic and some other things, and read the case. But eventually, the original officer released Graham after he found that no crime occurred in the store. The Supreme Court's decision is, in my opinion, not well written, and it wasn't very well explained. Regardless, that decision helped develop police procedures for stops that involved the use of force from that time period on, from 1989 on. In a nutshell, what you should take away from this case is that it stands for the premise that an officer cannot justify actions based on a hunch or by showing that they acted in good faith. Instead, you must carefully articulate facts and events that made the use of force objectively reasonable under the circumstances. That should sound familiar, because that's essentially what the focus has been in everything we've talked about to date. Now, Tennessee v. Garner, 471 U.S. 1, a 1985 case, focused on use of deadly force. It stands for the proposition that under the Fourth Amendment of the United States Constitution, a police officer may use deadly force to prevent the escape of a fleeing suspect only if the officer has good faith belief that the suspect poses a significant threat of death or serious bodily harm to the officer or others. Now, at the time, there was a Tennessee statute that provided that if a police officer is given notice of an intent to arrest a criminal suspect, the suspect flees or forcibly resists, the officer may use all the necessary means to effect the arrest. The Garner case was brought by the father of a teen who, after being told to halt, fled from the police over a fence at night in the backyard of a house that he was suspected of having burglarized. The officer used deadly force despite the officer's, by his own admission, being reasonably sure that the suspect was unarmed and thinking that the suspect was 17 or 18 years old and of a slight build. Now, some things should jump out at you. Number one, of course, I think you can understand that from the police's perspective, they were acting according to what the statutory law was at the time. And of course, that was challenged, and the Supreme Court held that Tennessee statute was unconstitutional insofar as it authorized the use of deadly force against, in this case, an unarmed, non-dangerous, fleeing suspect. As we've discussed in other contexts, go find them another day. Don't put yourself, them, and innocent people in harm's way, right? So it flows with that. The second thing, hopefully your knowledge of criminal law is such that you recognize that, it's the old, is it a burglary or a robbery? A robbery says that somebody has had something taken from them by force, possibly with a weapon. Much different circumstance than burglary. A whole lot of things wrong with the whole situation. But the decision again confirms that the use of force may not be used unless necessary to prevent the escape, and the officer must have probable cause to believe that the suspect poses a significant threat of death or serious physical injury to the officer or others. Now, those are the two cases that you need to keep in mind in this area, but you also need to recognize and be very familiar with the Illinois statute on the topic. And the statute that addresses use of force in making an arrest, including the use of deadly force, is found at 720 ILCS 5/7-5. It provides that prior to the use of force, officers are required to consider the totality of the circumstances. The totality of the circumstances language is also inserted into provisions allowing the use of deadly force, along with the requirement that the officer reasonably believes that the person to be arrested may cause great bodily harm to another. Consistent. An officer is not justified in using force likely to cause the death or great bodily harm when there's no longer an imminent threat of great bodily harm to the officer or another. So once that risk, that fear, that thing that caused the belief that there was an imminent threat of great bodily harm to the officer or another, once that ceases, you can't use that force. When feasible, the officer and the statute provides the word shall, and when we see the word shall, we think must. It's not an option. The officer shall, prior to the use of force, make reasonable efforts to identify himself or herself as an officer and warn that deadly force may be used. I think you've all trained on that and know that to be the case. An officer shall not use deadly force against a person based on the danger that the person poses to himself or herself. If a reasonable police officer would believe the person does not pose an imminent threat of death or great bodily harm to the officer or another person. So that's when we get into those suicide type situations. And hopefully in those circumstances you have a supervisor weighing in who's well trained. And there's plenty of training there too, because that's become an issue of concern. And then finally, the officer shall not use deadly force against a person who is suspected of committing a property offense. Again, think about Garner. Unless the offense is terrorism or unless deadly force is otherwise authorized by the law. Now, the statute provides some relevant definitions. One is deadly force. So here's what the statute says about deadly force. Deadly force means that any use of force that creates a substantial risk of causing death or great bodily harm, including but not limited to the discharge of a firearm. So nothing new here, okay? Nothing new here. Go back to what I said was that definition of use of force and deadly force, and nothing new here. Makes sense. The statute defines imminent. Imminent is defined as a threat of death or serious bodily injury. And it's tagged as imminent when, based on the totality of circumstances, okay, back to the totality of circumstances, a reasonable officer, so back to reason, a reasonable officer in the same situation would believe that a person has the present ability, opportunity, and apparent intent to immediately cause death or great bodily harm to a peace officer or another person. And imminent harm is not merely a fear of future harm, no matter how great that fear and no matter how great the likelihood of the harm, but it is one that from appearances must be instantly confronted and addressed. Again, this is what the basic expectation's always been on the use of deadly force. The major difference today, the video tells us whether or not it was imminent. All we need to do is watch the video from the three cases we discussed, the two cases that we discussed. If they had video, watch the video, it would tell the story, all the circumstances of all the situations that we've had to explain or endure. Now, is it always the case? No, it is not. But it is more likely than not that whether or not the bodily injury is imminent will be more clear based on a close review of all circumstances. And it's at this point that the statute tells us that the totality of the circumstances means all facts known to the peace officer at the time, or that would be known to a reasonable officer in the same situation, including the conduct of the officer and the subject leading up to the use of deadly force. Again, nothing new. The judge or jury is always going to consider the totality of the circumstances, everything that occurred. And if we assume that what occurred is in some way documented by video, the totality of the circumstances should be, at least to a great degree, able to be verified one way or another. At the end of the day, the totality of the circumstances, whether the threat of death or serious bodily injury was imminent and whether deadly force was justified, is going to be a question for the trier of fact, the judge or the jury. So you better be prepared to articulate your facts and the events that made use of force objectively reasonable under the circumstances in your case. But again, this is not new. It's not an unreasonable expectation just drummed up recently. It's really what the law expects all the way through everything you do in the course of your duties. 720 ILCS 5/7-5.5 provides prohibitions to the use of force by law enforcement. While this is new in the sense that it's contained in a statute, I think there are things that we could say were unspoken expectations, but most likely some of these things covered in policies and very much expected. Statute clarifies some things. It prohibits using restraint above the shoulders with the risk of asphyxiation unless the use of deadly force was justified. It prohibits involving contact with the neck or head that interfere with a person's breathing after the person no longer poses a threat to the officer or any other person. Again, kind of something we always expected. The statute clarifies that contact with the neck or head is not intended to reduce the intake of air, or that contact with the head or neck that is not intended to reduce the intake of air, I should say, is not a chokehold, but it prohibits the following activities: use of force as punishment or retaliation, discharge of any kinetic impact projectiles and any non-lethal or less lethal projectiles in a manner that targets the head, neck, groin, anterior pelvis, or back, discharge of conducted electrical weapons in a manner that targets the head, chest, neck, groin, or anterior pelvis, discharge of kinetic impact projectiles indiscriminately into a crowd, or the use of chemical agents or irritants, including pepper spray or tear gas, prior to issuing an order to disperse in a sufficient manner to ensure the order is heard and repeated if necessary, followed by some sufficient time and space to allow compliance with that order. So it prohibits those things. Again, the word reasonable, and whether those things are reasonable, well, I'd suggest to you that the law's always thought, and any time any of those things might have been done, the law would most likely deem that action unreasonable. And I'm not talking in a criminal sense, I'm talking in a liability, write a check and pay somebody sense. Final topic, use of force to prevent escape. So the statute merely states the expectations set forth by the United States Supreme Court in Garner. And that part of the statute is found at 720 ILCS 5/7-9. And it says the use of deadly force to prevent escape is prohibited unless deadly force is necessary to prevent death or great bodily harm to the officer or some other person. With this area of the law and your expectations for applying and operating within the law, I revisit something I've encouraged this entire course. And I really want to stress it here, okay? I've stressed it when I talked about something as basic as practicing putting somebody into custody, placing cuffs on somebody. Practice it, different scenarios, different levels of resistance, different size people. Practice the physical aspects of what you do, and especially with the use of force. By your hands and especially by your weapons. Practice the physical movements often, and with people you're going to be on the street and expected to serve with when the use of force may be necessary. Do this to protect yourself and others. Now, I get it. Finding time may be difficult, especially if you're, essentially overworked. You're expected to work more hours than you signed up to work because there are too few of you or resources or whatever. I get it that it might not be organized and paid. There may be some other restrictions, but you should advocate for it and you should find time to do it. You should practice the physical movements often with the people you're going to be on the street with and expected to use force with. You do it to protect yourself and others. Work on defensive tactics, takedowns, handcuff scenarios. It's worth your time and effort. The same goes for getting to the range, and especially if you have the virtual range options like may be available to you, to many of you, to run through scenarios and those kind of situations. Run through scenarios in this area. Practice the skill of being engaged, intentional processing. I get it. You might not be paid. I get it. You have little time as it is. But when you're dealing with use of force, just like when you're dealing with something that you may think is as simple as putting cuffs on somebody, it's not enough to just know what the law expects of you. You have to be intentional and practiced in your execution of the physical movements, of the mental movements, of everything that goes into exerting force. You have to be intentional and practiced executing those movements in a way that's reasonable under the circumstances. And that is what the law expects of you. I'm going to close with this. Not everyone is willing to do what you do. Not everyone is willing to commit to the level of focus, effort, and preparation this job requires of you every day. But you are. So know these basic expectations from this session and all other episodes. Work within, train for, and be intentional about following the law. I appreciate you. I hope you stay safe. If you need me, you know where to find me. Reach out.